Certainly separate from the person in charge component. That's clear if you look at the definition of enter or remain. And I would assert is also boxed off from the constitutional requirement.
So let me ask you about that. So it sounds to me like you're saying there are two alternative ways in which the state can prove criminal trespass in the second degree.
Yes.
One is through the lawfulness of the order to leave, which implicates the defense's constitutional arguments. And a second alternative way is that he was simply remaining in a place that was no longer open to the public, and that does not implicate the constitutional arguments.
Correct.
Okay. And if the state is relying on two alternative theories, then do we have a jury concurrence problem?
I believe it would be appropriate to instruct the jury that they must agree on one theory. But I believe that the way that the charge is written supports both theories, but certainly an instruction to say you all have to agree on either one of these theories. You can't be 3 and 3. Yes.
Okay. One more question or a series of questions with regard to Mr. McFarland just had a good point. You could elect also. He just messaged me. He does that sometimes.
I'm declining to elect at this time.
Okay, all right. Then you could do that. Especially if you're right about, anyway, never mind.
Perhaps I'll see how this motion shakes out.
Yeah. So then, with regard to the procedural issues on the constitutional arguments, I just want to make sure I'm understanding your argument on that, because I think it's an interesting issue, and I also think it's one in which the case law is not terribly clear. I think this kind of comes up sometimes with the lawfulness of police orders when we're talking about interference with a police officer. How do we instruct the jury on that, or is that an issue that's purely a legal one for the judge to decide?
Right.
So, are you saying that if I decide that I am the one to decide that the order was lawful or not, and that if I decide that it is lawful, that I essentially am telling the jury that it is constitutional?
You're asking the jury not to consider constitutionality. And if I may make a distinction between IPO and trespass, is that even though both include the terms lawful order, they're not used in the same way at all. In interfering with a police officer, the lawfulness of the order is actually an element of the crime in the statute. That's something that when the jury gets their elements that have to be proven, the lawfulness of the order is included. A lawful order for the purpose of police conduct is defined specifically in the ORS, not defined based upon hundreds of years of interpreting constitutional provisions.
Lawful order for IPO is defined in the ORS?
Yeah, there's like 5 or 6 things.
Is that new?
Let me check if
I don't think it is.
If I'm wrong, I'm wrong, but okay.
They're not built, don't they?
You know what, I actually have let me take a look at it.
And I don't want to go too far down a rabbit trail, but
it's important.
it's not in 162.225, which is definitions.
Right.
For all of the offenses, including IPO. Well, I don't think it's there, but your point is still well taken that it's a difference because it's a statutory term versus
Yeah.
something that case law provides.
Okay. And I apologize, I was incorrect. I'm certainly going to look into it a little more. But that's discussing statutory term element in the crime for police officers, for what's lawful for police officers. Lawful order is not an element of criminal trespass. Person in charges, but the lawfulness of the order is not. That's an affirmative defense that defense may raise to challenge the constitutionality of it. And while the case law is less than clear, I do believe that the language saying the proper vehicle, as well as the distinction between IPO, as far as it being in the statute, to the extent that the court has to make a decision, I think the evidence that we have, or not the evidence, but the law and case law is pretty heavily towards this being a judicial decision.
Okay. Thank you, Mr. Zemmel.
Thank you.
Mr. Gilbert, I'll let you respond.
When criminal trespass, when it's charged like this, on the theory that I think the evidence that makes most sense, I think that the lawfulness of the directive to leave is an element, and I think that's supported. There's language, maybe it's discussing another case in State v. White.
And let me ask you, Mr. Gilbert, are you aware of, because I can understand Mr. Zemmel's argument that it's complicated to instruct the jury on constitutional issues. You know, that's not necessarily to say that that's not what we should do, but are you aware of any other charges in which we do that, or have you seen any case law in which the Court of Appeals of the Oregon Supreme Court is telling trial courts that they're supposed to do that? I mean, can you think of any analogous context? I've just never heard of it.
I have.
No, I'm not. That doesn't mean it doesn't exist. But in Coney and Marmot, and then in State v. White, which the site is 2211 or app 210 from 2007. All of these cases talk about lawfulness of the orders and that being an element and how that's decided. And it is discussed as something that the state needs to prove. So, and it's also discussed in those cases that being lawful doesn't just mean that the person had the authority to give it. So I understand that the issue the court is struggling with is how do we instruct the jury about constitutional issues. I would submit that that's exactly what juries are for. Give them the Constitution and the evidence and the statute and let them make that decision. I don't have any instructions other than what I've presented or any other supporting authorities, but that's our position.
In response to the state's arguments with respect to criminal mischief 3 and criminal mischief 2.
With respect to criminal mischief 2, I would reiterate there's no evidence of damage. I understand that the difference here in opinion about what the law says is about what damage means. I would submit that it's got to be something more substantial than temporarily altering it in a way that could be quickly, easily fixed. I mean, that would, I think that would reach too broadly. It would criminalize behavior that clearly the legislature could not have intended to criminalize. For that reason, I would argue that it has to be more. It has to be not necessarily permanent, but substantial. And I would argue the same thing with respect to criminal mischief in the third degree. Yeah, so that's all I have.
All right, thank you, Mr. Gilbert. I appreciate the arguments of both counsel. I think both sides have very good arguments for all three of the charges. I am going to respectfully deny the motions for judgment of acquittal on all three counts, and I'll explain my reasoning. With respect to count 2, trespass 2, I agree with the state that there are two potential theories here from which the jury could conclude, a rational juror, when viewing the evidence in the light most favorable to the state and granting the state the benefit of all favorable inferences, which is the standard I'm supposed to apply at this stage of the proceedings. If a jury were to do that, a jury could find the defendant guilty based on the theory that he remained in a place that was no longer open to the public. The other issue is the more tricky issue, and that is the theory that implicates the defense's constitutional arguments, and that is whether or not Mr. Davis was given a direction to leave a public place from somebody who was in charge, and whether or not that order was lawful. The lawfulness of that order is what implicates the constitutional arguments that the defense has raised. I think that a rational jury could find that the order in this case was lawful and constitutional. To the point that Mr. Zemmel made, that this is something that essentially disposes of the constitutional issue, and that it should not be something that the jury should consider. I think it's possible that Mr. Zemmel was right about that. There are things about sort of the practicalities of asking the jury to consider constitutional issues that make that difficult, and that lean toward a conclusion that Mr. Zemmel was right about that. But I don't think that there's any case law specifically on point. And I also think that it is something that we can possibly instruct the jury on. I think it is difficult, but I think that we do that a lot with other complicated legal issues. And it is a little bit different than me just deciding whether or not a law is constitutional in the abstract. It's a decision that requires fact-finding, and it's a decision that requires matching up the facts that we've heard from witnesses to constitutional standards, and that necessarily requires credibility determinations and assigning weight to evidence and testimony, and those are all traditionally jury functions. Those are all functions of the trier of fact. So I think that it is appropriate to submit the issue of constitutionality to the jury, but I also think that a rational juror here could find that the orders given were lawful. So I think that that's something that I'm going to leave for the jury to decide. And I think that we need to be very careful about the jury instructions that we give in order to help the jury reach whatever conclusion that they're going to reach. And just a few words about that, just to sort of, I don't know that we're going to get to the point where we're going to talk about jury instructions today. We might talk about them a little bit more, but I'm thinking the jury instructions as provided right now don't go far enough in giving the jury enough information to decide what is constitutional or not. We need to be careful about walking the line between giving them enough information about the things that they're supposed to consider while not commenting on the evidence and directing them to a specific decision based on certain evidence. And I know that that's a fine line to walk. So I guess I would just ask counsel to think about that some more and maybe provide some more suggestions for how we might instruct the jury on the constitutional issue that's specifically implicated in this case. I think it's possible to do it. I do think it could be difficult, but I think we can probably do it with a few instructions. I would also, in doing that, ask counsel to take a look at State versus Babson. And it is